is the majority chief whip. I apologize for that. Honorable Rockson Dafeamekpor joins us. Thank you very much for your time and good morning to you.
Good morning, Thomas. Good morning to your listeners and your viewers. It's been a while.
Yes, it's been quite a while. But it's nice to have you on the line this morning. But Honorable Aqua from Odan says you led an agenda that he calls tyrannical. They don't have so many seats. They have one. An order has been given. They've gone to court. They filed a stay of execution. They've gone to the Supreme Court. All have been served on Parliament. But because you stood up and still insist that seat should be declared vacant, the clerk has gone ahead to do your bidding. What do you say to all that?
First of all, I wish Akwesi Akwa would have read Article 112, Clause 5 of the Constitution. And he would have also admitted to you that there is a subsisting order of the High Court of the Republic of Ghana, particularly from the High Court Commercial Division, Tamale, declaring the processes leading to the declaration of the parliamentary results on sometime 9th or 10th of December 2024 in favor of Nindam as null and void, and therefore the whole election ought to be rerun. I wish Akwesi Akwa would have admitted to this fact. And then he would have discovered that the clerk acted within his constitutional powers to inform the Electoral Commission because a High Court has pronounced a vacancy of the seat vacant in Parliament. But let's put all these matters aside and deal with the meat of the issue. We contested the outcome of the parliamentary elections in Kpandai. We didn't behave the way they behaved yesterday in Parliament because we had an overwhelming majority to hound Nindam out of Parliament or make Parliament ungovernable like they did yesterday. We went to court. We've been very quiet and patient with the court processes. For nearly 11 months, or for more than 11 months, we've been in court. And then the court gives the verdict, and the MPP says that, we should disregard the verdict and allow Nindam to stay in Parliament. Well, we don't have a political party whose interest we must protect. It's the only entity that matters that the NPP's interest must be protected. What about the NDC's interest? So we haven't led any tyrannical agenda. We are only saying that the law be respected. In any case, they are in court. They have filed so many processes, and let me mention them. First, they filed a notice of appeal against the decision of the High Court. Then they followed it up with application or notice for stay of execution of the order of the High Court. Then they changed lawyers. And then the new lawyer comes back or comes into the matter and also files a new notice of appeal, canvassing different grounds of appeal. Very, very interesting. Then applies for application or puts in application or notice for stay of execution. They have not withdrawn the earlier one filed by the first lawyer. So that's what we call multiplicity of processes. So in effect, that's an abuse of the court process. Then they have followed it up with an application, with a certiorari application at the Supreme Court. All these are pending. And yet, you go and organize teams that are pro-MPP, and you organize a press conference in Kpandai saying that, hey, nobody should come to Kpandai and do a rerun. Why? We are a nation of laws and order. Then they held a press conference at the foyer of Parliament, insulting the judge and the entire judiciary. They called the court a kangaroo court. All these don't seem to be working for them. So now they must come to the floor of the House and practically prevent the business of Parliament from being done. That is what the MPP has reduced itself. So nobody has set any agenda. We are simply following the law, and we are following the outcome of the processes that we went through in a court of law.
And he says that these processes have not terminated because they are in court. You have been patient so far. Why wouldn't you wait for at least even the Supreme Court hearing us on the 6th thing before that poll should be made for the declaration of a seat vacant?
Senna, where a law provides a procedure for a right to be remedied, it's only that procedure that will be followed. This is the authority in NTAC versus let me see authority. This is the authority in NTAC, the Supreme Court decision. All right. Boyfield versus NTAC. That's the authority. There's another authority that is Ghana Hotels Association versus Pick Plus Limited, Supreme Court. It says a mere filing of an application for stay of execution does not operate as a stay of execution of that order of the court. Now, there's the Court of Appeal rules that I believe Rule 20 of the Court of Appeals rules, 1997, Rule 1997, CI 19. No, yes, CI 9. It says that a mere filing of a notice of appeal does not operate as a stay. Do you know what the NPP did? In 2020, they came to Parliament to amend that provision because it needs to give them opportunity to have automatic stay and all those things. They came to Parliament to amend it to say that the mere filing of an application for stay cannot or shall not operate as a stay of the order of the court unless there's another order of the court staying the order of that court.
Oh.
Yes.
There was an amendment to that.
They brought an amendment, and that is, if you take the Court of Appeal rules, that is the amendment that NPP came to effect. And yet the same people are telling us that filing an application for stay should stay in the hands of a court of parliament of the electoral commission from carrying out its constitutional duties. That is what they are telling us. So now I attempted to make this argument 5 years ago in the Jachikwesin case. I hope you recall the rebuttal from the NPP on the floor of Parliament. I said Jachikwesin has been determined by a court in an injunctive application. The Supreme Court injuncted Jachikwesin that he could not hold himself as an MP. He couldn't get his salary. He couldn't function as an MP. He couldn't get his district assembly's common fund to work with until the final determination of a matter challenging his election. That one, it was an interim order. They carried it out and drove Jachikwesin out of Parliament. When I raised the issue of we having filed a notice of appeal and stay of execution, you had to watch them that day. They said I was espousing a wrong law, and that a mere filing of an application of stay does not operate as a stay, and that me, I was a bad lawyer. Today, those of them talking like that, they are not bad lawyers. So when it suits them, they make the point. So unless a court hears the application for stay and grants it, a constitutional an organ of state like Parliament will have to perform its functions. As for the Electoral Commission, that is why we have cited them in contempt. Because the Electoral Commission appears to be in cahoots with the NPP, and they are refusing to issue the rerun notice. And you cannot flagrantly disobey a court order to that extent. So as a party, we agree. And so we are back in court in contempt.
Hello, Nomo. Hello? 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 Okay, we seem to have lost him. We'll try and get him back on the line, especially on the issue of the conduct of the minority MPs and what he makes of that, because they say they were desperate. Like, when I put it to him, he said that they had tried every possible means to get the attention of the speaker. It had failed. That was why they decided that they will march on the majority. So that's an attempt to still catch the eye and the attention of the speaker. But like if you listen to our interview with Honorable Akwa, Alexander Kwesi Akwa, he insists that the majority leader, they prevented the majority leader from making any further. Okay, we have the whip back on the line. Thank you. We lost you there. You were talking about you going back to court.
So Senna, we are back in court. We've cited the Electoral Commission in contempt of court proceedings because we have come to the firm belief that the Electoral Commission is deliberately refusing to carry out the order of the court delivered on 24th of November 2025, directing them to rerun the Kpandai Parliamentary elections within 30 days. So now, we've lost over 15 days in this month. Today is the 10th. Today is the 10th of December. The order was issued on the 24th of November. It's been 16 days since. And the EC hasn't acted. So if this is not deliberate or alternatively supporting the NPP in this matter, then I don't know what it is. So we proceeded to cite them in contempt, of course.
Well, there are many Ghanaians who watched the scenes yesterday and are disappointed. As whip, it is difficult to say your side were actively engaged because it looks like they moved towards you. What would you say to what happened in Parliament in terms of the conduct of a minority and the marshals having to come in and the manner in which the appropriations were, the estimates were approved, among others?
Very disgraceful and embarrassing because you see, as a caucus in Parliament or a group in Parliament, you have tools available to you, which is to make your point on the floor of the House and allow the other party to respond, because you were accusing us of like the way Akwesi Akwa came to Radio Go to say that we were leading a tyrannical regime. You said all those things. So we had provided documents to set the record straight. Then people said they will not allow our leader or me to speak to set the record straight. Why? Are you the only people who have a right to speak on the floor of Parliament? And for 4 hours, they will simply not allow us to speak. Imagine we had used our might against them yesterday. We would have been blamed. They would have gone to town to cry baby and cry foul that, hey, we had molested them or used our super majority to intimidate them. But everybody saw what happened. They were behaving like spoiled children who wanted their way, really needed. Eventually, they said, until Kpandai is resolved, they will support us with government business. Hasn't the court resolved the Kpandai matter? It took the court 11 months to resolve the Kpandai matter. So it means that if the resolution is not effected in their favor, then hell must break loose. That is the kind of minority group we have. They should go back into time and learn how we offered minority positions 4, 5, 6 years ago, when we were there, we were very responsible minority. And that is why oftentimes when we made the point, and so the majority then wanted to have their way, we walked out. We never subsided the house. We never blocked proceedings from being carried on and all. But yesterday they even wanted to take the mace. This level of lawlessness ought not to be tolerated in Parliament.
And what steps will be taken? Because Honorable Akwa says they were desperate. They had tried to get the speaker to listen to them. He had failed. They had done everything, and they realized that you were just going ahead. That's why they moved to where they moved to. That they were desperate.
Desperate about. Senna, I think when people lie, you should be able to expose them. They were desperate that they won't allow us to talk. In Parliament, everybody has a right to speak, especially when it catch the attention of the speaker. The speaker recognized the Honorable Mama Ayaga, my leader, and they said no. Ayaga shouldn't have a say, shouldn't speak, shouldn't talk, because they, the minority, won't listen to him. Where would this be tolerated?
They say
In any case, then why are they in court? If they would do all this in Parliament, think that they can have results, then why are they before the Supreme Court? Today we are before the Tamale High Court.